Thanks, everyone, for joining us at the Project Censored radio show on Pacifica Radio. I'm your host, Eleanor Goldfield, and we're very glad to welcome back to the program Chip Gibbons, who's a journalist, researcher, and policy director at Defending Rights and Dissent, and is currently working on a book on the history of FBI political surveillance for Verso Books. Chip, thanks so much for joining us again.
Thank you so much for having me back. And one day when I come on this program, you can announce the book is no longer being worked on. It's out, but that day will not be today.
Good things take time. Like when you just put together an empire in 200 years, it doesn't go as swimmingly as when you have as much long time as the Roman Empire did. So I want to start with a recent article that you wrote in Jacobin magazine. For listeners, a note: we're recording this on June 9th, but this won't air until July. So there will likely be updates in the things that we're talking about. So don't come after me for not having a crystal ball and foretelling the future. But also the things that we're talking about will still be pertinent in July unless there's some asteroid that hits the Earth, in which case you won't be hearing this anyway. So Chip, I want to hone in on something that to me speaks of the fragility of the First Amendment. And I would say also the Eighth Amendment when it comes to actual legal safeguards. The First Amendment, of course, being the one that supposedly protects, among other things, freedom of speech, and the Eighth being one that protects against excessive bail, fines, or cruel and unusual punishment. Now, as a parent, I would certainly say that it is cruel to not allow a father to be present at the birth of his child, to barricade him behind bars and put him in weeks of agony to even know whether or not he'll be able to hold him. But focusing in on the First Amendment for the moment, let's talk about what you write about in your piece, the stacking of the deck. As you write, quote, immigration judges are not part of the federal judiciary created by the U.S. Constitution. They are part of the Department of Justice, the same body often seeking deportation. Sitting above individual immigration judges is the Board of Immigration Appeals. Members of this body are appointed directly by the Attorney General, who can also modify or overrule their decisions, end quote. And you also go on to outline a ruling that further stacks the deck, a ruling back from the Clinton era. So I was wondering if you could talk a little bit about that and the larger proverbial deck that is stacked against not only folks like Khalil, but indeed anyone trying to access the First Amendment.
Sure. So I think let me just start off by making a distinction between the immigration court and federal court. All of these cases, Mahmoud Khalil's, Moshe Mudali's, Badar Kansori, and Rumisa Ozturk are very confusing, I think, for not just a lay person to follow, but even someone with a legal background, because they're happening in two different legal systems at once. They're happening in immigration court and they're happening in federal court. And you get this weird sort of situation. For example, in Ozturk's case, the immigration judge denied her bail, but then the federal judge granted her bail. And I think there's this sort of whiplash between the two legal systems, and it gets very, very confusing for people. So immigration court is not what's called an Article III court. If you remember back to ninth grade government, and I barely remember back to ninth grade government, other than that we learned the 4 goals of U.S. foreign policy were world peace, human rights, economic prosperity, and I don't know, just goodness, just general goodness. I remember that.
Doing really well, by the way.
Yeah, I remember that. But, Article 2 is the branch of the U.S. Constitution, or the part of the U.S. Constitution that sets up the federal judiciary. And when we think about courts at the federal level, we usually think about courts that are part of the Article 2 federal judiciary. Immigration court is not part of that. It's what's called an administrative court. It is created by the executive branch. It is part of the executive branch. Immigration judges work for the Department of Justice. The Attorney General under U.S. law is the moving body in a deportation, and the immigration judges work for her. If you don't like what the immigration judge does, you go to the Board of Immigration Appeals. They're appointed by the Attorney General, and when they make their ruling, the Attorney General can modify or overrule it. So this is basically kangaroo courts, putting it politely. But in addition to these courts, you also have, as we all know and love, usually not love though, federal courts. And these are set up by the Constitution. They are more independent, although there are some issues with Congress court stripping, taking away the federal court's authorities to hear certain cases involving immigration law. And what each of these individuals have done, Consori, Madali, Ozturk, Halil, is to file a habeas petition. And a habeas petition, that's been a right since the Magna Carta and before. That challenges unlawful detention. So they are in federal court saying they are being detained unlawfully while the immigration courts are moving on. And you mentioned this ruling from the Bureau of Immigration Appeals, not Affairs, that states, so all of these deportations are being brought by Rubio under this Cold War era law that the Secretary of State can basically expel someone if they make a determination that their presence in the U.S. poses adverse foreign policy consequences for the U.S. It's very unclear what that means. The law has not been frequently interpreted. There's a 1990 conference report in the Congress that gave examples of when it might apply. One would be like denying a visa to the Shah of Iran, or when something violates a treaty. That's not the circumstance here, even remotely. And what Rubio has done is, I'm sorry, let me go back a minute. And the court has ruled, the Bureau of Immigration Affairs has said that if the Secretary of State makes a determination, basically presents this magical piece of paper, then the immigration judge is powerless to do anything other than find the person is quote unquote removable. That is, they can be expelled from the country, deported. Just because you're found to be removable doesn't mean you will be deported. After you're found to be removable, the next stage is relief from removability. But at the first stage, there's basically no defense here. If the paper is signed, the person is removable. The State Department wins. And
I wanted to ask you something because recently on the show, Mickey and I discussed how the amazing Kristi Noem, Secretary of Homeland Security, completely 180'd the definition of habeas corpus and said that she felt that the definition was that Trump had the right to remove anybody he basically didn't like, which is in fact the exact opposite. And if we assume
the opposite is irrelevant. I mean, habeas corpus is about detention. I mean, habeas petitions are frequently used to challenge deportations, but the reasoning for this is very convoluted. But at its core, a habeas petition is the right to challenge your detention. I believe habeas corpus in Latin is like bring forth the body or something. I don't know. I'm having flashbacks to ninth grade government class.
But I'm curious, like, if a law is only as good as it's understood, what good is filing a habeas petition if the government's like, I just think it's not the thing that it actually is?
Well, habeas corpus has been defined since the time of the Magna Carta. As bad as it is when we have executive branch officials redefining the law as we go along and making things up, I do not believe Kristi Noem is going to get away with rewriting the Magna Carta. Right. Like I in this case, I'm confident that her gibberish before whatever was it, the Senate or the House, is just not going to have that big of an impact. And, in court, they're not arguing habeas corpus is the president's right to deport someone. They're arguing that habeas doesn't apply here because of all of these court stripping measures that Congress has enacted, mostly in the 90s under Clinton. It's fascinating how much of this goes back to Clinton. It's also very interesting because you keep hearing all these Trump supporters saying, like, well, no one ever, Clinton deported all these people or Obama deported all these people and the courts never intervened. And it's like, well, the one time anyone has ever heard a federal challenge to this law, it was under Janet Reno, and Janet Reno lost at the district court level. So it's, the Clinton administration was not doing so well in court on the immigration level.
Well,
and some of the other ones they were.
I was wondering if you could talk a little bit more about that. What are these Clinton era clauses or precedents that are really hammering folks like Khalil right now?
So, well, Halil hasn't been hammered by them. They've gotten around them. But in 1996, they passed something called the Illegal Immigration Reform and Immigration Responsibility Act of 1996, and it stripped the rights of the federal judiciary from hearing a number of challenges to the immigration proceeding. For example, one of the provisions reads quite, I have it in front of me. But I have 10,000 tabs open, of course. That no court shall have jurisdiction to hear any cause or claim by or behalf any alien arising from the decision or action by the Attorney General, who the immigration judges work for, to commence proceedings, adjudicate cases, or execute removal orders against any alien under this chapter. And at this time, there was a group of people known as the Los Angeles Eight, 7 Palestinians, 1 Kenyan, who were being deported for their First Amendment protected speech. You'll be shocked by this, Eleanor, about Palestinian rights. Who could have guessed that coming? Who would have guessed that? And judges had found that the administrations were selectively enforcing the immigration law against them because of their political speech. And the Supreme Court interpreted this statute once again in a case that's ADC v. Reno. All of these immigration cases, it's someone v. Reno. That's our friend Janet Reno, not my friend. But and they said that you could not bring a challenge to selective enforcement of immigration proceedings, and the court could not hear it under this. So while federal courts can hear a broader range of claims than immigration courts, Congress has consistently acted to strip their ability to hear many of these cases and limit them.
Yeah, so what does that mean for, because you talked about these parallel cases happening in different court systems. What does that mean for someone like Khalil, who is basically being torn between these two courts in two different states at two different speeds and rates? What does that mean?
Well, I think it's worth pointing out that in all 4 of the cases, the big ones, Consori, Halil, Ozturk, Madawi, that the Trump administration has tried to raise all of these provisions and rulings to state that the courts cannot hear these habeas petitions. And as bad as the federal judiciary is, and as bad as the law is, in each of these cases, the courts have flat out said, no, that's not true. That what's happening here is egregious or narrow enough that we can actually hear these cases. So I think that speaks to the exceptional nature of what Trump is doing. And we have judges ruling that there are likely First Amendment issues, that granting bail to individuals is necessary in order to end a chill of First Amendment on First Amendment rights, not just of these individuals in question, but a chill that's being felt broadly throughout the country. You had one judge, I believe it was in Vermont, stating that there was an exceptional circumstance. That was one of the legal prongs that had to be met to grant bail, that there's an exceptional circumstance because the country is in a situation like the Red Scare, or not a second Red Scare, or like the Palmer raids. They're both the Red Scares. Both Red Scares are back. Isn't it exciting? 2 Red Scares at once. Yeah, and that's sort of where we're at. So these legal hurdles are quite daunting, but in these cases, they have not yet caused any major problems.
Well, and I want
one problem that has come up, and this is quite fascinating, is that the law is all about the Attorney General, or in some cases the Secretary of Homeland Security, and this is about the Secretary of State who's doing it. He's the party initiating these proceedings. And the other thing here that gets talked about is the habeas petitions are not challenging the removal proceedings, they're challenging the detention. Now, if you're being detained under the Rubio determination, you pose a consequence for U.S. foreign policy, and that's unconstitutional in that context. But you're also being deported under that, and there's no constitutional view of that deportation. What does that mean for the rule of law? What does that mean for democracy? And I don't actually even know what happens. This is sort of a novel legal situation. If you have 4 federal judges saying in each of these cases the detention is unconstitutional, and then in the other cases you have the immigration judges being like, well, we have to move forward with deporting them. In the Halil case, there is a request for a preliminary injunction. I assume it's the same in the other cases to void the Rubio determination. Now, if the Rubio determination is voided, that would remove the grounds for removability in 3.5 of these cases. Although with Halil, they originally started on the foreign policy determination, and they then brought a second charge against him that he had admitted information on his immigration application. The defense has challenged that, and some of this stuff they're arguing he omitted. It's not even clear to me why that would have to come up. Like, he didn't mention he was in a student group. Like, that's not really lying on your immigration application. And in other cases, they're like challenging the dates he worked for the British government in Lebanon. In line with U.S. foreign policy on Syria, I'll note, and the defense has just come up with like, guys, you're pulling bad information off a website. Like, here's the actual dates. But the immigration judge, who works for Pambandi, has refused to hear that evidence because she's refused to make a ruling on that charge. She is exclusively focused on the foreign policy determination, once again, because under the wonderful law of immigration court, once the attorney general, or not the attorney general, the secretary of state signs that magic piece of paper, and we've seen what Rubio's given them, it's quite sparse. It's very perfunctory. But he's not even really trying. He doesn't have to, you have to order removability. And it's interesting because they're also trying to argue in court that that determination can't be reviewed by a federal judge. And none of the federal judges are having that. And the most fascinating thing to me was I was in the courtroom for the Consori bail hearing, and they made the argument that once Rubio signs this magic piece of paper, federal judges can't overrule it because it's his inherent foreign policy powers. And the judge noted, "You've never given me that piece of paper." He's like, "That's true, Your Honor, and we haven't given it to the immigration judge either." In Halil's case, they gave it to the immigration judge, but the judge was just like, "You're telling me if you provide me with this piece of paper, I can't do anything, but you're not even proving to me it exists," which is really astonishing.
And yet at the same time, judges can just decide what evidence they will hear. I mean, it reminds me of the court that Kiriakou went to and that Assange was going to go to, where the judge was just like, "I don't want to hear your defense. Like, so I'm not going to hear it." And it's like, well, then how do I speak on my own behalf if I'm not allowed to show you any defense?
Look, I'm not defending the judiciary at all, but generally when they ask you, "Can you provide me this piece of paper?" and you say, "No, I will not do so," they get very mad, right? Like the judge in the Consori case, I've been in her courtroom for another case. I'm an Espionage Act defendant, and she is like horrendous, pro-government, overturning other judges' granting of bail, ironically. And in this case, she's just like, "Guys, I keep asking you for evidence. You keep not giving it to me while you're tweeting about the case." You know, and she's like, I just have to accept all of Consori's claims because you've provided no evidence to the contrary while you keep tweeting about the case. And I've noticed that since then, they also keep tweeting about it. So, yeah, I recognize there's 4 cases here. We're going back and forth between.
Right. And I'm just curious, why do you feel that Khalil's case is different, and what does that say for other people who are in the crosshairs of this, anti-Semitic so-called speech?
Sure. So let me just note it is June 9th, 2025, 11:25 a.m., and that this interview will air later. But as of the moment that we are talking, there have been 4 of these high-profile cases: Consori, Madali, Ozturk, Halil. In each of the 4 cases, they have brought a habeas petition challenging the constitutionality of their detention. In each of the 4 cases, the individual bringing the petition has filed a motion for bail pending a final decision on the habeas petition. To get bail in an immigration proceeding while you have a habeas petition, the same standard applies as someone who is in prison post-conviction. trying to challenge their conviction and getting bail. And the listeners are probably thinking, Chip Gibbons just misspoke. I've never heard of such a thing happening before. And you probably haven't heard of such a thing happening before because it's so rare and it's so such a high standard, right? If I'm on death row or I'm in court or I'm in prison having been convicted by a jury and I feel like my trial was bad, I generally don't get bail and get to come out from, death row or prison or wherever. But there is a standard that allows for that. And that is the same standard that applies to these 4 people. And the standard is very much like there has to be an exceptional circumstance, a very rare circumstance. And in 3 of the 4 cases, a federal judge, including one whose courtroom I've been in and is not liberal in granting bail to criminal defendants, have found that high bar exists, and these individuals must be granted bail pending a final decision on their habeas petition. In Halil's case, a motion was made, and the judge has never, as of June 9th, 2025, 11:27 a.m., the judge has never ruled on it. I believe the motion was originally filed back in March. So why has this judge not made a ruling on this when every other judge has ruled in defense of the petitioner? I have no clue. What's most recently happened is the judge has made a ruling on a preliminary injunction in Halil's case, and that puts the judge further along in the legal proceedings in the other cases, but still ignoring this bail application. And the preliminary injunction asks for 3 things: that Halil be released, that the Rubio determination be voided, and that the Trump administration's policy of arrest be the Trump administration be stopped from enforcing their policy of arresting, detaining, deporting, maybe is the 3rd thing, non-citizens who speak out for Palestine or criticize Israel. And the judge has made a ruling in that case that on the Rubio foreign policy determination, Halil is likely to prevail because it is no reasonable person would know that law that allows Rubio to do that applies to domestic speech. It should apply only to situations like the Shah of Iran, something that's on the tip of everyone's minds these days. And the other charge he's bringing, which is that the claim that he misled on his omitted information on his immigration application, he's unlikely to prevail. But as the judge noted, the immigration judge has made no ruling on that. The immigration judge has refused to hear evidence about that because they refuse to rule on it because they don't have to, because the Trump administration has provided them that magical piece of paper signed by Marco Rubio. Now, usually a likely to succeed is the first prong in getting a preliminary injunction. Usually that's the end of the story. The judge finds the rest of the stuff. The second part is you have to show irreparable harm. And it's fairly easy to show irreparable harm when the Constitution is at stake, right? Courts have said a violation of First Amendment rights is inherently an irreparable harm. But for some reason, the judge who has found he's likely to succeed on his first claim about the constitutionality of his detention has stated he needs more evidence about the harm that's being caused by it. I can't explain that to you. So Halil is still in jail or still detained in a private prison, private immigration prison. I went on the website, Eleanor, and they're based on family values. The whole website is about how their immigration detention center has family values. Really sounds like a wonderful.
I'm guessing it's like the Manson family because that's the only family I can think of.
Let me clear it. When I say it sounds like a wonderful place, Halil has given really strong evidence about how horrible the conditions are here. It is the Manson family values. Yes, I think you're correct on that one. I mean, he's being held in squalid conditions, separated from his child. This whole goofy website about how we detain immigrants in a civilized manner based on a family small business values. Not with
mom and pop prison, right?
It's a mom and pop prison, multiple prisons. So I'm a little bit skeptical about the family.
Mom and pop chain prison.
This prison. Based on family values, yes.
Yeah, no, it sounds delightful. We only have a few minutes left, but I wanted to talk about something else that you mentioned in your article that doesn't I don't feel like it gets a lot of coverage, particularly as it pertains to these legal proceedings. Now we know that there's like Baytar and the Canary and like blacklists that, but I think people don't often times look at those as, oh, that could actually be like a legal problem for people. So I was wondering if you could talk a little bit about the role of blacklists in these legal proceedings and, how that's really like a US institution, because going back to ninth grade, we only hear about the creepy blacklists in regards to like East Germany, not as a US institution that now has, for instance, in its crosshairs, people like Miss Rachel, who's a beloved childhood educator. I was wondering if you could just, with the few minutes we have left, talk a little bit about these blacklists and their role in these legal proceedings.
Well, Defending Rights in Dissent, where I work, is engaged in an investigative project into these deportations and detentions that is using the Freedom of Information Act. And one of our main goals is to determine the role and the extent of the role of groups like the TAR, Canary Mission, and the ADL. If you'd like to support this project, because filing the Freedom of Information Act is not an easy process, you usually have to take them to court. I would really strongly recommend you visit us at rightsanddissent.org. And, we are preparing to potentially sue multiple government agencies over the failure to disclose information about these blacklists. It's just one part of the larger investigative project. But we know that before Trump was inaugurated, Batar, which is this creepy right-wing Zionist group that other Zionist groups in the 1930s accused of being fascist, right? Like the other Zionists in the 30s are like, you guys are wearing brown shirts. What's up with that? Literally what happened. Um, and that they began claiming they were using facial recognition to make a list of students to deport. When Mahmoud Halil was arrested, they took credit for that. Other people like Ozturk and Kansari, we know, have been targeted by Canary Mission. And, the ADL just has a really rancid history here on this topic, going back to the 80s and 90s. In the 90s, they were engaged in illegal surveillance of groups in California. So we're trying to figure out the extent of organizations like that, what role they are playing in these deportations, right? Did they give the names to Rubio and then Rubio made the orders off of that? Or are they just boasting? We're also trying to get information about the executive orders we know this is based off of and how they're being interpreted. We're trying to get sort of the copies of the determinations that Rubio is making and any sort of policy memorandum showing the interpretation or implementation of what we know to be a systemic program targeting non-citizens for their speech. And I would note that I don't think this is going to stay with non-citizens. The Heritage Foundation, who is one of the groups that's taking credit for this type of use of immigration, abuse of immigration enforcement, has made it clear that immigration enforcement is not their final goal. Their final goal is equating protesting for Palestine with material support for terrorism. So we are really trying to figure out what's going on. I'll also note that a lot of what we've heard about in the immigration context is social media vetting, where they are allegedly using artificial intelligence. So what that means is they are building a mass surveillance apparatus that uses artificial intelligence to find and identify individuals who engage in political speech they don't like. Today, those individuals are supporters of Palestine or just opponents of dropping, 2,000-pound bombs on babies in tents. And the punishment is immigration enforcement. But once the government has the power to find anyone on social media for their speech and punish them, we should not believe it will be limited to that. And I would even challenge some of these people on the right who I don't agree with on anything, who think this is wonderful, right? Do you want the Pete Buttigieg administration to have that surveillance tool? Because they can use it for IRS audits, they can use it for FBI assessments. Once the Pandora's box is open of the government has this technology to go through all of social media and pull up people for their speech. You know, they can select those people for IRS audits. They can select them for FBI assessments. They can select them for denying a green card. They can select them for not letting them in the country, right? All of those different things. And it's very, very troubling. And I don't think we should be very concerned about where this is going.
Yeah, absolutely. And the level of, I mean, the power that they have. And I'm reminded of an interview I did years and years ago, like 15 years ago, where the person I was interviewing said, we all break the law. I mean, if you think about it, the user agreement for signing up for 17 magazine says that you're 18 years or older. How many people have actually read the entire iTunes user agreement and things like that? So it's like, if they want to go after people, if they then have the power and the lack of accountability that allows them to do these things, everybody can be in the crosshairs for anything such seemingly as menial as signing up for 17 magazine and being under 18. So it's like, this is the kind of toolkit that anybody can use for against anybody.
No, I agree. Yeah. It's
yeah, no, it's horrifying, and people should be against it regardless of who is in the crosshairs. So Chip, thank you again so much for taking the time to sit down with us and trying to tease out these very convoluted ties in our remarkably wonderful legal system that I have no problems with. Folks, do check out Chip's work over at Defending Rights and Dissent. That's rightsanddissent.org. And thank you again, Chip, for coming on the show.
a pleasure. Thank you for having me so many times.